Okay, thanks for having me. The cases I was asked to talk about are Missouri versus Fry and Lafler against Cooper. Two cases that deal with the Sixth Amendment right to the effective assistance of counsel, or as I like to call it, the latest episode in the Supreme Court's TV show, Criminal Defense Lawyers Behaving Badly. So the question really, and I'll get into the facts of the case in a minute, the cases. The question is really, does the Sixth Amendment right to the effective assistance of counsel protect a trial right, or does it protect more broadly the right to a fair criminal adjudication? And if it's the second, what do we actually mean by fair? There's a few issues sort of embedded in this, but it's interesting. The Supreme Court has recently showed a somewhat surprising interest in expanding the right to counsel and some of the other Sixth Amendment trial rights. At the same time, and Professor Luna will get into this maybe, that it's really shrunk some of the protections under the Fourth and Fifth Amendment. So there's really some signals that the Court is willing to entertain a more robust Sixth Amendment jurisprudence as it's shrinking some of the other protections. The cases are also very interesting, in my opinion, because it gives us a glimpse into lawyering on the ground and some of the consequences of lawyering, both good and bad. The facts, briefly, Missouri versus Fry arose from a very modest charge of driving on a revoked license. Mr. Fry was charged in Missouri with driving on a revoked license. It happened to be his fourth offense, which made it a felony. That carried a 4-year maximum sentence, and the prosecutor sent a written plea offer to Mr. Fry's lawyer saying, here is the offer. Mr. Fry can plead guilty to the felony, and I will recommend only 10 days in jail and the rest of the time suspended. Or Mr. Fry can plead guilty to a misdemeanor. I'll drop this felony down to a misdemeanor, but he has to serve 90 days in the county jail. Those are your options. Now you're thinking to yourself, what would I do if I'm Mr. Fry's lawyer? Should I take the felony with 10 days or take the misdemeanor with 2 days? Well, there was another clause in the offer. This offer expires on December 28, 2007, which was about 6 weeks after it was made. So what does the defense lawyer do? There's a range of reasonable lawyering options you could do at this point. He made a note on the offer, quote, probably should, and then put it in his files and didn't tell Mr. Fry about it. To be clear, that is not within the range of reasonable lawyering options. And so December 28th came and December 28th went, and the deadline for the offer expired. Mr. Fry showed up in court at the end of February, initially entered a not guilty plea, but then decided to plead guilty. Nobody ever brought up, either his lawyer or the prosecutor, this plea offer that had been extended, ignored, and then rejected, or withdrawn, rather. And so finally Mr. Fry enters what's called an open plea with no deal, sometimes a naked plea, to the initial charge of felony driving while revoked. And for that, he received a sentence of 3 years, active jail sentence, prison sentence. So Mr. Fry went to prison for 3 years, where he somehow then found out about this offer when he tried to challenge the sentence and got a new lawyer for his post-conviction proceedings. His lawyer looked through the file, found this plea offer with the notation, probably should, and by all accounts, both the lawyers and Mr. Fry's, that was never communicated to him. Now note, one thing that's going to become important later, at his plea hearing, remember, Mr. Fry stood up, as happens in every plea proceeding in this country, or should, and said, I understand I have the right to trial, I understand I have the right to call witnesses and to confront the witnesses, and I choose to give up those rights to enter this guilty plea. And remember, he got a 3-year sentence on a driving while revoked. Okay, Mr. Cooper, meanwhile, up in Michigan, is charged with assault with intent to murder and some other charges related to that. What Mr. Cooper did, again, the facts of both of these cases are essentially uncontested. Mr. Cooper, while, and I'm sure there's a backstory here, but I don't know what it is, while walking toward a woman, pulls out a handgun, he's 6 feet away, aims it at her head, and shoots. He missed. And she ran away, but Mr. Cooper kept shooting. He shot 4 more times and he hit her twice. Once in the thigh and once in the buttocks. And she's in the hospital for 2.5 weeks with some fairly serious injuries. Mr. Cooper is detained almost immediately by a police officer who witnessed the shooting And he's detained almost immediately, running from the scene. They do a gunpowder residue test. He's got gunpowder on his hands. Mr. Cooper never very meaningfully contests that he was the person who fired the shot. So the initial plea offer was to the assault with intent to murder with a below guideline sentence, right? And so below the state guidelines, which would give him a sentence of between 51 and 85 months, okay, or 7 years. His defense lawyer does advise him of the plea. Okay, so he's a step ahead of the Fry defense lawyer. And he says, you got an offer of 51 to 85 months on this assault with intent to commit murder. Mr. Cooper immediately says, I want to take it because I'm guilty. And he says this in front of the prosecutor in open court. In front of the, I want to take it because I'm guilty. And the lawyer says, not so fast. Let's go in the witness room. They go and have a little talk. And his lawyer says, you shouldn't take the deal. And I'll tell you why. Because the injuries were below the waist. Okay? And if you shoot someone below the waist, they can't convict you of assault with intent to murder. Okay? Remember, he aimed at her head from 6 feet away and fired a gun. Here's what the Sixth Circuit said, basically in their entirety, about the defense lawyer's argument that because the shot was below the waist, the government had to dismiss the assault with intent to murder charge. Counsel was wrong. And so, on advice of counsel, Mr. Cooper rejected the offer, expecting that assault with intent to murder charge to go away. In fact, as you might predict, it didn't. They went to trial. On the first day of trial, the government said, we'll extend you another offer. It's not going to be as good, right, because now we've prepared for trial. But you can plead to the same charge, and we'll agree to a sentence range of 126 to 210 months. So that's 10 to 18 or so years. Mr. Cooper had rejected this one, too. So he goes to trial, and the jury convicts Mr. Cooper of the assault with intent to murder and every other charge that he was charged with, and he is sentenced to a sentence of 185 to 360 months. Okay. Anyone remember the initial plea offer? 51 to 85 months. Okay, so it's at least 3 times as bad, and realistically probably much, much, much worse than that. And now remember, just as Mr. Fry had a perfectly valid and proper plea hearing, where he validly waived his rights, Mr. Cooper had a trial, where he was able to confront the witnesses against him, and he had, by all accounts, the effective assistance of counsel at trial. So, both defendants claim they were deprived of the effective assistance of counsel, but they both got a problem, and that's what the cases are about. Because they both have a problem in that the government in each case says that if there was deficient performance, there was no prejudice. There was no constitutional prejudice because it was cured by, on the one hand, a valid waiver of rights, and on the other hand, a valid exercise of trial rights. Okay, so it's different from some other cases where a celebrated case or infamous case, from your point of view, Padilla versus Kentucky from last year, which it provides the real backdrop for this. In Padilla, Mr. Padilla's lawyer, and this is why I say it's the latest episode in defense lawyers behaving badly, advised Mr. Padilla, who is not a citizen of the United States, although he lived here for 40 years, and was charged with trafficking in marijuana, 40 pounds of marijuana. Mr. Padilla said, is this going to affect my immigration? And his lawyer said, don't worry about it. You've been in the country so long, you have nothing to worry about. Mr. Padilla pled guilty and was relatively promptly informed that he was going to be sent back to Central America. And so the Supreme Court reversed that and held that it was an invalid and involuntary plea because it was motivated by the misadvice, the affirmatively wrong advice of his lawyer. And so in that case from last year, the Supreme Court showed a willingness, for the first time really, to intervene in a constitutional sense in the plea bargaining process, right? And so they said that's not a valid, knowing, and voluntary waiver of trial rights because it was misinformed. It was informed by the affirmatively wrong advice of counsel. Here, Mr. Fry and Mr. Cooper have a problem in the prejudice problem because they both either went to trial or validly waived their rights. The governing case of ineffective assistance, Strickland versus Washington, requires a defendant, a petitioner, to show, on the one hand, deficient performance of counsel. we can all agree. We've got that in both of these cases. And in fact, all of the courts who've reviewed it agree. But also actual prejudice. And so that's the question before the court, is where is the prejudice if it has been cured in some sense. One of the questions here is, a defendant has no right to a plea bargain. Right? A plea bargain is extended essentially at the mercy or at the pure discretion of the prosecutor, the executive branch. And so one of the questions is, if a defendant has no right constitutionally to a plea bargain, how can a defendant's Sixth Amendment rights to effective assistance of counsel be violated by ineffective assistance at that stage? Right? The Sixth Amendment protects critical confrontations, as Scott pointed out. And so if you don't have a right to a plea bargain, how do you have a right to the effective assistance of counsel in a plea bargain? Okay. One other issue, and then I'll give my prediction. I'll give my prediction, which historically is meaningless. So I warn you about that. I guess historically you're better off betting against me. Even if the petitioners in this case can show deficient performance, which everyone agrees they can, and actual prejudice, which is going to be trickier, there's a question about what the remedy is. Right? In Padilla versus Kentucky, the court said that plea was involuntary, and so we're going to send it back down for further proceedings. And Mr. Padilla, you're free to go to trial on this. That's still pending what Mr. Padilla is deciding to do. In these cases, if you think about it, what can a court order now? If they say, Mr. Fry, you can go back down and we'll pretend you're in the same situation as before, there's a real question as to whether the courts, even the Supreme Court, can say, all right, you, state prosecutor in Missouri, we order you to re-extend the same plea offer that you made 5.5 years ago to Mr. Fry, and we order you to offer him that misdemeanor 90-day plea offer. Similarly, in Lafler versus Cooper, it's not very clear that the Supreme Court can order the executive branch to re-extend that plea offer from before trial. So there's a question of the separation of powers lurking there too. Okay, my prediction, and again, this and 4:25 will get you a cup of coffee at Starbucks. I don't. The question here is really is the Supreme Court on a trajectory to extend the protections that it did in Padilla, or have they granted cert in these cases to sort of establish an outer limit? I think that's what they've done here. I think there's this prospect of gamesmanship that the government brings up, that the prosecution side brings up in both of these. If you go ahead, Supreme Court, and say we are going to grant relief to the petitioner in this situation if the attorney didn't extend the plea offer or gave some bad advice, then you're going to have defense attorneys going around and purposely not extending plea offers and purposely giving bad advice. I don't think that's going to happen. I don't think the Supreme Court is going to buy that argument. I just don't think there's much there. But I think they're going to be concerned about the prospect of tinkering around too much in the pretrial bargaining process. And I think that one argument that has been raised in support of reversal is that if the Supreme Court starts tinkering around here, prosecutors are going to be less willing to extend plea offers. And I think there's something to that one. So my prediction is that the courts are going to find no prejudice in either of these. I should mention also, for those federal courts fans out there, Lafler versus Cooper is a habeas case. And so that adds another level of difficulty for the petitioner, who's got to show that the state courts, the Michigan courts, violated a clearly established principle of law, which I don't think they're going to be able to do. So that's a look. So I'm predicting reversal on both of these. I'm not going to tell you who's going to vote which way, because I always get those wrong. And I don't think they're going to reach this very interesting issue of whether courts can order prosecutors to go back in time and re-extend plea offers. Anyway, very interesting case, sort of signals the future of this. It's important because, for one thing, those of you who have taken criminal procedure or paid attention to the news know, if the Sixth Amendment, right to effective assistance of counsel, only protects trial rights, it only protects about 4 to 5% of the people who go through the criminal adjudication process in the country. Because somewhere around 95% of cases are resolved by plea. And so that's what's important about these cases. We live in a world where most all cases are resolved by plea. That is not something that the Supreme Court has really dealt with yet. Now we've got a couple of former prosecutors on the court, excuse me. And it may affect somehow the reasoning with Justice Sotomayor and Justice Alito, who have actually had experience in the plea bargaining process. So pay attention. It'll be interesting. Thank you.